Hi guys, it's Kathy. I hope you're doing well. Nothing too crazy happens today, don't worry. I did put out a video, a sneak peek of a trial that I'm getting right now that's still going on. That's pretty crazy. But if you haven't seen it, you should at least see the sneak peek. It's his attorney is over the top. He's like a little child. He's like a mean little child. Mean. All right, I'm going to play a 14-second clip. That's most unfortunate. Ready? Here we go. Oh, wait.
All right. And then position number 2024 CR087, the state versus Destiny Cheyenne Dees. Your Honor, that would be.
Is that is that the most unfortunate name you've ever heard, or what? Hold on. Hold on, maybe you didn't hear it. Listen.
All right. And then position number 2024 CR087, the state versus Destiny Cheyenne Dees. Your Honor, that would be.
That is the most unfortunate name I've ever heard in my life. No wonder she's here. She probably has a lot of rage. A lot. All right, let's go. Let's go with this guy. Let's stick with this judge for the first one.
All right, sir, if you'd be kind enough to raise your right hand for me, please. Do you solemnly swear or affirm the testimony you're about to give in this matter is the whole truth and nothing but the truth, so help you God?
Yes, sir, I do.
Thank you. You can put your hand down now. All right.
Nothing crazy happens, guys. It's just a nice, slow Southern court where he gives wise words after all the court stuff is over.
In regards to Mr. Breedlove, what is the recommendation?
Your Honor, with regards to Mr. Breedlove, he will be entering a guilty plea to the only count in the indictment. We anticipate a recommendation of 3 years probation, a $500 fine, drug and alcohol conditions, Fourth Amendment waiver. If he completes, does everything he's supposed to, and no further violations, it's my understanding the state has no objection to him terminating in a year and a half. Additionally, something to bring to the court's attention, he was scheduled to be in court on January the 2nd in front of Judge Wall with her calendar call in Wheeler County. He did not get that notice. Since that point in time, he has advised Wheeler County. They do have his new address. I've confirmed that with Ms. Carol there, Ms. Bragg, and she has indicated to me that they have the address. And we would request that that bench warrant be rescinded. He has been placed on a February 3rd calendar, I do believe, with Judge
Does the
Wall.
state have any objection to that, Mr. Childers?
No, Your Honor.
That would just be part of this.
All good, Nan. Hasn't happened all day today. Yes, I think it's over. Thank you, Nan.
All right, that bench warrant has been rescinded. Sir, if you'd give us your name and age.
Lorenzo Todd Breedlove, 52.
Are you a United States citizen?
Yes, sir, I am.
How much education have you had?
12, GED.
Can you read and write?
Yes, sir.
Can you hear and understand my questions today?
Yes, sir, I can.
Are you suffering from any physical or mental disease here today?
No, sir.
Are you now under the influence of any medications, drugs, alcohol, or narcotics?
Just blood pressure medicine.
Does that in any way interfere with what you know, what you're doing here today?
No, sir.
Listen, guys, blood pressure medication is important. If you take it, make sure you take it. That's all I'll say.
All right, you're charged with possession of methamphetamine. Do you understand that charge?
Yes, sir, I do.
And do you understand that this court can sentence you from 1 to 3 years with the Department of Correction and require you to pay a fine up to $100,000 in regards to that charge?
Yes, sir.
And do you understand that you have the right to stand on your not guilty plea in this matter?
Yes, sir.
And do you understand that if you stand on your not guilty plea in this matter, you'd be entitled to a jury trial?
Yes, sir.
And do you understand that at a jury trial, you'd be presumed innocent of this charge, and that presumption of innocence would remain with you throughout the jury trial unless a jury here in Montgomery County were to find you guilty beyond a reasonable doubt?
Yes, sir.
And do you understand that the state would have the burden of proving your guilt beyond a reasonable doubt?
Yes, sir.
Do you understand that at a trial, you'd have certain constitutional rights?
Yes, sir.
And do you understand you'd have the right to confront and cross-examine each witness that the state called to testify?
Yes, sir.
And do you understand you'd have the right to subpoena your own witnesses to testify in your defense?
I just like how they put the H in front of the W. What, when, where, why.
Yes, sir.
And do you understand you'd have the right to testify yourself and present evidence in your defense?
Yes, sir.
Do you understand you'd have the right to be free from self-incrimination, meaning that you couldn't be forced to testify?
Yes, sir.
And do you understand you'd have the right to assistance of counsel during trial, meaning Ms. Cameron would be there to assist you in the trial of the matter?
Yes, sir.
And do you understand you'd have the right to be present during the whole trial?
Yes, sir.
And do you understand you'd have the right to remain silent at that trial if you so desire?
Yes, sir.
And do you understand that by pleading guilty here today, you're waiving your right to a jury trial and these constitutional rights that I just reviewed with you?
Yes, sir.
And do you have any questions at this point regarding these constitutional rights for either the court or your attorney, Ms. Cameron?
I know, he hasn't been on since before Christmas. He just hasn't been on. I look every single day for him and he's not on. He'll be back. I'm sure he'll be back.
Yes, sir.
You do?
No, sir.
Okay. Ms. Cameron has been representing you. She's standing at the podium with you. Have you had enough time to talk with her about your case?
Yes, sir.
And are you satisfied with the services that she's rendered to you in regards to this case?
Yes, sir.
Have you ever been convicted of a felony prior to today?
Yes, sir.
Okay. Then how do you plead to the charge of possession of methamphetamine in case number 24 CR010, guilty or not guilty?
Guilty.
Are you in fact guilty?
I was in the vehicle. Yes, sir. I'm guilty.
So are you in fact guilty?
Yes, sir.
And did you, on the 25th day of March 2023, here in Montgomery County, Georgia, unlawfully possess methamphetamine, a Schedule II non-narcotic controlled substance with an aggregate weight of less than 2 grams in violation of the Georgia Controlled Substance Act, contrary to the laws of the state of Georgia?
Like I said, I guess possession would mean I was in the vehicle with it. So yes, I did possess it. Yes, sir.
Yeah. You're guilty as a party to the crime.
Yes, sir.
Okay. Is your plea here today freely and voluntarily given?
Yes, sir.
Has anyone tried to force you or coerce you into entering a plea of guilty here today?
You could. You could start the whole trend. It could start with you.
No, sir.
the state would be kind enough to give the court a factual basis for the plea.
Yes, Your Honor. On or about the date set forth in the indictment, the defendant stands before you was traveling through Montgomery County where law enforcement saw that he had a headlight that was not, defective. He was pulled over for that. He failed to dim those headlights. When talking to him, I believe he said that the headlight was defective. However, that's what he was initially pulled over for. Officer noticed that the defendant was acting very nervous and very strange. He asked him if he'd taken anything. He indicated that he had smoked some marijuana earlier. He asked him for consent to search the vehicle, and consent was given by the defendant. The vehicle was searched, and a small amount of methamphetamine was found in the panel door, not inside the panel, but in the wherever the
In the pocket?
the pocket, that's, I couldn't find the word.
Okay.
The pocket of the door panel, Your Honor. He was arrested and charged with that, and he is pleading to that one count.
Very good. Mr. Breedlove, it's my understanding of the recommendation in this matter, where you're pleading guilty, you'd get 3 years probation, a fine of $500 plus any and all fees and add-ons. You'd be under normal drug and alcohol conditions. You'd consent to a waiver of your Fourth Amendment rights. And if you have complied with all of the terms of your probation and paid all your fines and fees, your probation could terminate after a year and a half.
Yes, sir.
You understand that?
Yes, sir.
And is that the agreement reached between you and Ms. Cameron on the one hand and the district attorney's office on the other?
Yes, sir.
Have there been any other promises made to you in return for your plea of guilty?
No, sir.
Mr. Breedlove, I'm holding the document. It has the caption of your case on it. It's called an acknowledgement and waiver of rights and intent to enter a guilty plea. I show you that document.
Yes, sir.
You familiar with this document?
Yes, sir.
This document contains 22 items on it, and outside those 22 items are the initials LTB. Are those your initials?
Yes, sir.
And did you place your initials out beside those 22 items?
Yes, sir.
And in so doing, does that reflect that you understood
Yes, sir.
and truthfully answered each of those questions?
Yes, sir.
Does it further reflect that you have not been misled or induced to enter this plea by fraud or mistake, threat, or coercion?
Yes, sir.
And does it also reflect that you freely and voluntarily answered those 22 questions so as to give this court a basis for accepting your plea of guilty?
Yes, sir.
You signed the document.
Yes, sir.
Ms. Cameron signed the
Linus has a girlfriend? Since when?
document.
Yes, sir.
And you understand that this
Everybody's always drunk.
document is going to be made part of the record in your case.
Yes, sir.
Part of the terms of your probation require you to consent to the waiver of your Fourth Amendment rights. Excuse me. Which means that while on probation, you and your property are subject to being searched without your consent and/or a search warrant. And anything found on you and all your property could be used against you in a court of law. Do you understand that?
Yes, sir.
And do you so consent to the waiver of your Fourth Amendment rights?
Yes, sir.
Had you stood trial in this matter and were convicted, you would be entitled to an appeal. If you couldn't afford an appeal, this court would appoint you a lawyer to, if you can't afford a lawyer to handle your appeal, this court would appoint you one. Do you understand those rights?
Yes, sir.
And do you understand that by pleading guilty here today, you're giving up your rights to such an appeal?
Yes, sir.
All right, Mr. Breedlove, I intend to accept this plea of guilty and the recommendation, but I'll give you the right to withdraw your plea and you can proceed to a jury trial. How do you wish to proceed?
Guilty.
All right. Court accepts Mr. Breedlove's guilty plea in this matter, finds that there's a factual basis for the plea, finds that he has freely, voluntarily, and knowingly entered into such plea. This court sentences him to 3 years with the Department of Corrections. However, he can serve the same on probation. He'll pay a fine of $500 plus any and all fees and add-ons. He'll be under normal drug and alcohol conditions. He has consented to a waiver of his Fourth Amendment rights. He would be entitled to early termination after a year and a half on probation if he's complied with all the terms, both special and general, of his probation, and he has paid all his fines and fees. Mr. Breedlove, you'd have 30 days from the date that this guilty plea is entered in which to file an appeal to this guilty plea if you wish. You'd also have the right to file a motion to withdraw your guilty plea if you file the same within this specific term of the Superior Court of Montgomery County. Have you been issued a weapons carrying license?
No, sir.
I also need to inform you, you'd have 4 years from the date that this sentence becomes official in which to file a petition for habeas corpus if you feel your constitutional rights have been violated in any way. Let's let the plea be entered.
Please been entered, Your Honor.
All right. Anything further from the state in regards to Mr. Breedlove?
No, Your Honor.
Ms. Cameron?
Nothing additional, Your Honor.
All right, Mr. Breedlove, you are old enough to know, bud.
Yes, sir.
Evidently, you got some issues over in Wheeler County somewhat like these.
Older, that's right. I don't, like I said, if I would had known, I would have been in court. I was working, the gentleman right back there, the date that it happened, or I would have been in court. I do not take,
I know Mr. Hughes.
I take my court dates seriously, I do. I don't waste the court's time, so I apologize for that, I do.
It wasn't me.
No, I
over there,
know.
So it was probably Judge Wall, but anyway, I mean,
But
you're awful close going to chain gang.
Yes, sir.
And, you know, if you keep messing with that stuff, that's
Oh,
where you're headed.
That's what I was gonna tell you today. I'm clean, and I could have peed in the cup for you or whatever, so I'm well
Well,
away from it. I mean,
I'm not
That was very gracious of him.
real good on names, but I'm real good on faces.
Yes,
And
sir.
if I see you again, I'll remember.
yes, sir.
Good luck to you, sir.
Thanks, sir.
I'll see you in February, okay? You
Yes,
gotta
ma'am.
make your probation.
Can you go?
Yes, it's fine in the dishwasher. I said yes, 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 it is. So, he offered to pee in a cup for the judge. That's so nice. And I'm just upset that none of you had anything to say about his name, Mr. Breedlove. Come on, guys. Wake up, wake up, wake up. All right. Now, you think, though, down south is where people are, you know, they talk slow, everything's nice and slow. No, 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 no. No, no. Let's go to the Dakotas. Here we go.
Mr. Jackson appears on behalf of the state in this matter.
I'm pretty sure this is North Dakota. I'm pretty sure.
Mr. Sua appears personally and without counsel. Good morning, sir.
Good morning, sir. How you doing, Your Honor?
I'm doing well.
Okay.
So in this case, the defendant is charged with care required.
Yep.
This is a moving violation. That citation was issued on November 20, 2024.
Yes. Honor.
I'll give you an opportunity to speak, but for now, you just wait, okay? All right. So That citation was issued on November 20.
I did find out this judge worked for I think the DMV for a while. He said it in a different case that I'm not showing. Explains a lot.
On November 29, the court received a signed request for hearing, which was dated November 25, but again filed on November 29, together with the $30 cash bond that is required. We're here for the administrative traffic hearing.
Smith, I'm showing receipts right here. I'm showing it. It's happening right in front of you.
The court finds that the request for hearing was within the statutory 14 days. The defendant posted the $30 cash bond as required by the statute.
Hi,
And
Amanda.
today's hearing is within 90 days of the request for hearing. Mr. Jackson, do you have an opening statement?
Your Honor, we believe the evidence will show that the defendant was operating a motor vehicle upon a highway and was not operating the vehicle in a careful and prudent manner based upon both the weather and road conditions at the time. Thank you.
Thank you. Mr.
Okay, just so you know, if you guys do listen to this court case, it's a nail biter. It really is a nail biter.
Sua, do you have an opening statement that you'd like to provide to the court?
Yes, Your Honor.
Go ahead.
All right, on that day, my company, I work at Goodyear for 13 years, and I've been doing roadside assistant. And on that day, the customer called 4 different people to come and service in that day. And for a year, they stopped making us to come over 50 miles away. But 2 days before that day, my boss said that the company said we can go anywhere longer now. They told us we can go longer than 50 miles. So on that day, the weather conditions were very bad, and the customer called.
Your Honor, I'm going to object. This is testifying, and he hasn't been sworn.
So, Mr. Sua, I'm going to give you an opportunity to present sworn testimony that will be subject to cross-examination.
Okay.
When I asked for an opening statement, basically I wanted any statement that you have that previews what evidence you think that you will present. So for right now, I'm going to overrule the objection, Mr. Jackson. I understand why you made it, but nevertheless, the opening statement is just a brief preview that says the evidence is going to show Judge XYZ. Right?
Okay.
Okay. You have anything else, sir?
Yes.
Okay.
Okay.
So, that's all I'm looking for is that brief preview of what do you think
Yeah,
the
very
evidence is
brief.
going to show.
Yep. Okay. On that day, when I was driving, I got a service call done on my way back. I went on the bridge, like the overhead, and when I came from on that bridge, I skated and I mistakenly hit the brakes. I panicked. That's what caused me to go down that road, and we only got a rear wheel pickup. So I could have gave myself out, but I couldn't get out that day because the company only provide a rear wheel drive.
Okay. Mr. Jackson, call your first witness.
Your Honor, I'm going to call Shelby Volk.
Please come forward, sir. If you can stop and raise your right hand. Sir, for the testimony you're about to give, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Please have a seat in the witness chair. Make yourself comfortable, and when you're ready, please state and spell your full name for the record.
Shelby Volk, Shelby, last name V as in Victor, OLK.
Go ahead, Mr. Jackson.
Thank you, Your Honor. Mr. Volk, where do you work?
The Barnes County Sheriff's Office.
And were you working on November 20th, 2024?
Yes, I was.
And where were you? Were you in Barnes County?
Yes, I was. I was along Interstate 94.
Okay. And on that day, did you have occasion to meet with the defendant in this matter?
Yes, I did.
What was the reason that you came to meet the defendant?
It was a call for service for a vehicle that was in the ditch.
Okay. Do you recall who made that call?
Not offhand, no.
Now, can you tell me a little bit about the weather on that day?
The weather on that day, I think we had like a little bit of like misting going on, then turned to ice, and it was basically glare ice. We had multiple calls for services for vehicles that had lost control and hit the median, the ditches. I think I had like 3 or 4 that night, that time span.
Okay. And are you aware of any businesses running late or being shut down on that day because of weather?
Not offhand, but I would imagine it would compare some of that ability to open a business on that, with those conditions.
Let me rephrase a little bit. Was this one of the more significant weather events that we've had this year?
Yes, because when I get out of my patrol car on the road surface, it's almost like there was ice, but there's no snow on the ice. It's like you dumped water on the ice and it was just a slip and slide.
Okay. Can you tell me approximately where this event occurred?
It was west of Valley City, approximate offhand. I'd have to refer back to the citation that was written. That's where the location was.
Okay. Now, when you came across Mr. Sua, you earlier indicated that his vehicle was in the ditch. Did you have any conversations with Mr. Sua about how he ended up in the ditch?
Briefly, yes. He was heading back to Fargo and his speeds were over 50 miles an hour.
Okay, do you know what the speed was on the area of road that Mr. Sua was?
That's a posted 75 mile an hour zone.
Were the weather conditions good enough to be going 75?
No, they were not. In my 4-wheel drive Durango with snow tires, I was having issues even at 35.
So, the defendant indicated that he was going, I believe you said around 55.
Correct.
Me too. Me too.
Did you ask Mr. Sua about the events that caused him to enter the ditch?
The posted speed is 75. No one was driving 75 that day. His speed is a little fluctuating. This officer said 55. He says 45. I don't know.
Can't recall parts of that conversation offhand.
Yep. Every year we have a farm show. It's huge, and every year it snows. It's like farm show knows how to pick the exact day it's gonna snow. Hi, Butterfly. Yay.
And based on your training and experience, could a vehicle going off of the roadway and ending up in the ditch endanger, cause harm to the defendant or somebody else?
Correct. Defendant, other motorists, property, that sort of thing, anything along the roadway.
Nothing further, Your Honor.
Mr. Sua, do you have any questions of this witness?
Yes, when he came that day,
So, Mr. Sua, it's not a time for you to editorialize or tell me what you
No,
said
sir.
happened. So
Okay.
if you have any questions for the witness, ask the witness, not me.
not really a question. Yeah, I just told him I was gonna come to court
All right.
when he gave me that ticket.
Sir, you can step down. Thank you.
Thank you, Your Honor.
Mr. Jackson.
Your Honor, he's been subpoenaed. He can be released.
All right. Sir, you're released from your subpoena. Mr. Jackson, any other witnesses, evidence, or testimony?
No, Your Honor.
State rests.
State rests.
Mr. Sua, do you have any witnesses, evidence, or testimony that you want to present?
Maiko, when he was driving and he slid off the road and into the ditch, he called the police for help. I need help. I just slid from the icy road into the ditch. Will you please come and help me? And he got a ticket.
Oh, I already said it from the beginning, but I couldn't explain much, yes or no.
So you want to explain your side of the story?
Yes, I wanted to. Because
All right. So what I'm going to do is I'm going to have you stand up and I'm going to have you raise your right hand for me. Sir, for the testimony that you're about to give, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
yes, so help me God.
I'll have you sit in this witness chair. Make yourself comfortable.
Our kids have to log hours on snow and ice or really bad driving conditions to get our driver's license here. We have to have so many regular hours and then so many snow, ice, bad weather hours. So they know how to drive in snow and ice before they even get their license.
Because you're representing yourself, sir, I'm going to allow you to just tell me your story in a narrative form. You can just tell me your story,
Okay,
but
Your
Mr.
Honor.
Jackson might ask you some questions after the fact, okay?
Okay,
All right. Go ahead when you're ready.
okay. On that day, my company, like they forced us to come this far in a bad weather to risk our life. There was no reason of me coming that day, but being that they told us that we can't refuse a service call. If when we refuse a service call, we're going to get penalized. And that customer broke down. He had 4 tires that I needed to come and get done. And I came down here and risked my life. I never been scary in my life when that happened. So I actually called to get help when he came.
Yeah, he called for help. I'm pretty sure 1 or 2 of my kids, the first time I took them out, there was snow all over the roads. I'm pretty sure the first time they got behind the wheel of a car, there was snow on the road. It's fine. I mean, we know how to drive on snow.
When he came that day to help me, he only asked me one question: how fast were you going? And I told him I was going 45 to 50 miles per hour that day. And the reason of me going in that ditch that day, when you go when you're driving and you go on the underpass, some part of it is dry. So when I came out of there, that's how I slipped. I saw it, and when I hit the brakes, that's how I ended up in the ditch. So it's more to it with the company, but I won't spend my spend all your time to explain all about it. So that's what I got to say for now. Yeah.
All right. So I want to make sure I understand what you're saying. You're saying that you were driving 45 to 50 miles an hour
Correct.
on the interstate
Right.
because the weather was bad.
Because the weather was bad, yeah. Usually that's 75 miles per hour.
Yeah, I understand.
Yeah.
But the weather was bad, and as a result, you slowed down to 45 to 50 miles an hour, right?
Correct. All the way from Jamestown coming back, yeah.
All right. And as you were driving,
Mhm.
there was a dry patch. And then as you came out of the dry patch, you hit some ice. You hit your brakes and kind of panicked, and you ended up in the ditch.
Right. That's exactly what happened, yeah.
Okay. And then you called for,
I called for help. Yeah.
okay. All right. And you're driving a company vehicle?
Yes, Your Honor. Yeah.
All right. Anything else you want to tell me, sir?
Oh,
I doubt it was a state of emergency. I don't remember them saying that. It was just icy. The roads were just icy.
well, after he gave me the ticket, and I asked him, I said, how fast you think I can go? And that was his word. He said, wherever miles you comfortable as driving. You know,
Mr. Jack,
So what he just said there, if you didn't understand, he asked the officer. So the speed is 75 miles per hour on this road. This guy says he was going 45 to 50. The officer said that he was going 55, which is still well under 75. So this guy asked the officer, "Well, what's the speed limit then?" And the officer said, "Well, whatever you're comfortable with driving on this road."
Jackson, any questions of this witness?
Yes, Your Honor. Mr. Sua, did you pass anybody while you were driving that day?
no, it wasn't too many people on our road. Yeah.
You would agree with me that you did in fact end up in the ditch that day?
Say that again?
You did end up in the ditch that day while you were driving?
While I was coming back, yeah. The road condition was the same when I was coming, because I came over from Fargo, yeah. And the customer told he called about 4 other people, and then nobody wanted to go. And the only reason why I came, because I didn't want to get penalized at work,
He told the officer how fast he was going.
because they just told us we can go. That's the only reason I left Fargo to come here, because if 4 people around town refuses to go, why should I come all the way down here from Fargo? And I wouldn't have did it because I didn't want to get penalized at my job. I lost my job. Yeah, and we only got a rear-wheel drive pickup. We don't have a 4-wheel drive pickup or all-wheel. So usually the rear-wheel drive, it's not good. It's not good driving in a slippery weather.
Thank you. Nothing further, Your Honor.
Sir, you can step down. Any other witnesses, evidence, or testimony, sir? Have a seat. Any other witnesses, evidence, or testimony that you want to present to me?
No, it was just me.
All right. So, Mr. Jackson, any rebuttal testimony, witnesses, or evidence?
No, Your Honor.
All right. Mr. Jackson, any closing argument?
Your Honor, the defendant here was driving. The weather conditions were not ideal for that. You heard officer testimony that even in his vehicle, which was equipped with the right type of equipment to handle bad weather, he still had issues. This was not, the defendant was driving his vehicle upon a highway. The not being careful and prudent enough at the time and having due regard to the surface
No, he will lose his job if he's convicted.
and weather conditions present at the time. This act, which ultimately resulted in Mr. Sua ending up in the ditch, endangered not only his life, limb, or property, but could have also resulted in somebody else getting hurt. Thank you, Your Honor.
Mr. Jackson, the trooper also, or the deputy also testified that he responded to 3 or 4 calls for people in the ditch that same day. Did all of them get cited for care required?
Your Honor, I do not know that information.
All right. So why in particular, Mr. Sua?
Your Honor, I'm not sure. I don't have those other instances in front of me. So I'm not sure.
Mr. Sua, do you have any closing argument that you'd like to present?
Yes, I'm a DOT driver, and one of the main reasons why I came up here is I don't want points on my license, and that can cost me to lose my job. And I got three kids and stuff, and I need that job. That's why I've been on it. It's not easy to stay on the job for 13, 14 years. So I've been maintaining that job. I'm not happy I got a rear-wheel drive pickup, but it's a job. I got to go and help people, like the officer. I'm like a DOT guy. I go and help other people when they break down. So why would I get penalized for going to help people and mistakenly enter in the dish? And that's the main reason why I'm here, to see if I can get help, not to get points on my license and stuff. If not, I just pay that ticket.
Okay. Anything else, sir?
That would be awful.
Mr. Jackson, any rebuttal?
No, Your Honor.
All right. Court's considered the statute, North Dakota Century Code Section 12. North Dakota Century Code Section 390901.1 reads, any person driving a vehicle upon a highway shall drive the vehicle in a careful and prudent manner, having due regard to the traffic, surface, and width of the highway and other conditions then existing, and shall give such warnings as are reasonably necessary for safe operation under the circumstances. No person may drive any vehicle upon a highway in a manner to endanger the life, limb, or property of another person. Here, the court heard testimony from the deputy that Mr. Sua was operating a motor vehicle on Interstate 94, which has a wide right-of-way. It is a divided highway. It is as wide as it gets in North Dakota. It has wide ditches, and the reason it has wide ditches is to provide for people that might, on occasion, slip and end up in the ditch. It's designed by the Department of Transportation to be a safe motorway with no obstructions in the vehicle right-of-way. Here, the court heard testimony from both the deputy and from Mr. Sua that the road conditions weren't the greatest, that it was misting, and as a result, things were slippery and icy. The court heard testimony, although somewhat diverging testimony, on Mr. Sua's speed. The deputy testified that Mr. Sua stated that he was driving about 55 miles an hour, which is 20 miles an hour below the posted speed limit. Mr. Sua testified that he was traveling between 45 and 50 miles an hour. And so the range, the uncontested range, is 45 to 55 miles an hour, which in any event is 20 to 30 miles an hour lower than the speed limit. The trooper testified, the deputy testified, that at 35 miles an hour, he was
He
having
did hit
issues
black
in
ice.
his squad vehicle, which does have snow tires and all-wheel drive or four-wheel drive capabilities. Mr. Sua testified that he was operating a vehicle that did not belong to him. The vehicle belonged to his employer, and it's a rear-wheel drive vehicle. He's not happy about that. The reason for the travel doesn't really matter to the court. The issue is just whether or not Mr. Sua was making reasonable efforts to drive in a safe and careful manner. Here, it appears as though there were multiple people that ended up in the ditch. The court does not know whether or not other individuals were cited for care required or for reckless driving. Here, Mr. Sua testified in an uncontested manner that there weren't many other vehicles on the road, that he did not pass any other vehicles on the road. And so the endangerment argument is somewhat minimized because there was not much traffic on Interstate 94 at the time and place of the accident or the leaving the roadway. The court is going to find by preponderance of the evidence that Mr. Sua was driving in a careful and prudent manner, although he did end up in the ditch. There's testimony that he hit dry patches and then icy patches, and when the vehicle hit that icy patch, that's when he lost control of the vehicle. Again, the court understands the deputy reached a different conclusion and cited Mr. Sua. The deputy was certainly doing his job, and the court is now doing its job in finding that the evidence doesn't support conviction or a finding here that he was driving without care required. He was driving again 20 to 30 miles an hour under the speed limit. Ultimately, that turned out in retrospect not to be slow enough to keep him on the roadway. But at the time, changing road conditions are certainly something that he was trying to adjust for. He just didn't adjust enough for. And as a result, he ended up in the ditch with no damage to the highway, no damage to other vehicles, no damage to himself. So the court's just not going to find sufficient evidence to sustain conviction for care required at this time. So that'll adjourn the matter. The bond will be refunded and the matter will be adjudicated not guilty. Anything else, Mr. Jackson?
No, Your Honor.
Anything else, Mr. Sua?
Oh, Your Honor.
All right, we are adjourned in that matter. All right, thank you.
Snow tires. Yep. I'm so glad he did the right thing. Thank you, Judge. Thank you, Judge Thornton. All right, we're going back down south, guys. We're going back down south because did you really think I was going to get that woman with the most unfortunate name ever, Miss Dees, and not show her case? Nothing crazy happens, but her name is Miss Dees.
Position number 14, 24CR016A, State versus John Allen Kite.
I followed Mr. Kite.
And then position 17, 24R24025, the State versus Quink Smiley. And then position number 19, 24CR031.
Hold on, guys. It's 38 seconds in. I have to restart this video. Linus, this is how today started. Are you ready? It's only 14 seconds long.
All right. And then position number 20, 24CR087, the State versus Destiny Cheyenne Dees.
Your Honor, that would be.
Yeah, so this is that's where we're going right now. He's doing four people in one.
And then position number 19, 24CR031, State versus James Caleb Brinson.
He's in the back.
All right, let's get Mr. Kite to be the first one. Mr. Smiley be the next one. Mr. Brinson be the next one. And we're going to kind of play a game of Simon Says.
Mr. Brent,
Come out west end of
do you want to just handle all three of these? Instead of me standing at the door.
All right, and then I need position number 20, 24CR087, the State versus Destiny Cheyenne Dees. Ms. Dees?
And whatever's on that sheet is what he's doing. What's on that sheet is what he's doing. Here, get out of the way.
All right, if everybody would be kind enough to raise their right hands for me, please. Do you solemnly swear or affirm the testimony you're about to give in this matter is the whole truth and nothing but the truth, so help you God? Yes, sir. All right, very good. All right, when I point at you, I need you to answer my question, okay? State your name and age.
John Allencott, 10/20/1997.
Quantic Metron Smiley, 2/1975.
James Caleb Branson, 7/1/1986.
Destiny Diggs, 08/1903.
All right. Are you a United States citizen?
Yes, sir.
Yes, sir.
Yes, sir.
How much education have you had?
High school diploma.
High school.
GED.
Some call me.
Okay. Can you read and write?
Yes, sir.
Yes, sir.
Yes, sir.
Yes, sir.
Can you hear and understand my questions this afternoon?
Yes, sir.
Yes, sir.
Yes, sir.
Yes, sir.
Are you suffering from any physical or mental disease here today?
No, sir.
No, sir.
No, sir.
Are you now under the influence of any medications, drugs, alcohol, or narcotics?
No, sir.
No, sir.
All right. Mr. Kite, you're charged with, you say this is going to be a misdemeanor plea?
It is, Your Honor. He's going to plead to count one reduced to criminal trespass.
All right, you're going to plead to a reduced charge of criminal trespass misdemeanor. Do you understand that charge?
Yes, sir.
And what's Mr. Smiley pleading to?
Your Honor, he's going to plead to count one, and the remaining counts are going to be null crossed.
All right, Mr. Smiley, you're pleading to a charge of obstruction of an officer misdemeanor. Do you understand that charge?
Yes, sir.
And what is Mr. Brinson pleading to?
He's pleading as alleged to a misdemeanor obstruction of an officer, Your Honor.
Do you understand that charge? And then Ms. Dees is pleading to a simple battery. Do you understand that charge, Ms.? All right. And do you understand that this court can sentence you from 12 months, up to 12 months in jail and require you to pay a fine up to $1,000?
Yes, sir.
Yes, sir.
Yes, sir.
All right. And do you understand that you had the right to stand on your not guilty plea in this matter?
Yes, sir.
Yes, sir.
Yes,
And do you understand that if you stand on your not guilty plea in this matter, you'd be entitled to a jury trial?
Yes, sir.
Yes, sir.
yes, sir.
And do you understand that at that jury trial, you'd be presumed innocent of this charge, and that presumption of innocence would remain with you throughout the jury trial unless a jury were to find you guilty beyond a reasonable doubt?
Yes, sir.
Yes, sir.
Yes, sir.
And do you understand that you would have all of the following constitutional rights: the right to confront and cross-examine each witness that the state called to testify, the right to subpoena your own witnesses to testify in your defense, the right to testify yourself and present evidence in your defense, the right to be free from self-incrimination, meaning that you couldn't be forced to testify, excuse me, the right to assistance of counsel during trial, the right to be present during the whole trial, and the right to remain silent.
Yes, sir.
Yes, sir.
Yes, sir.
Look what Brent just typed. And now look who came in. Good morning, Bill. He did. He didn't pick a good time, didn't he?
And do you understand that by pleading guilty, you're waiving your right to a jury trial and these constitutional rights that I've just reviewed with you?
Yes, sir.
Yes, sir.
And do you have any questions at this point regarding these constitutional rights for either the court or your attorney?
No, sir.
No, sir.
The Public Defender's Office of the Oconee Judicial Circuit's been representing y'all, or representing you in this matter. Have you had enough time to talk with them about your case?
Yes, sir.
Yes, sir.
And are you satisfied with the services that they've rendered to you in regards to this case?
Yes, sir.
Yes, sir.
Then, Mr. Kite, how do you plead to the
That would be hilarious. That really would be hilarious. Now I have to know.
charge of reduced charge of criminal trespass in case number 24R016? Guilty or not guilty?
Guilty.
Are you in fact guilty?
Yes, sir.
And did you, on the 28th day of May 2023 here in Montgomery County,
He scares me. He goes into fits of cough sometimes.
damage a 2021 Jeep, the property of Amber Braddock, contrary to the laws of the state of Georgia?
Yes, sir.
That not correct?
Yes, sir.
Okay. And then, Mr. Smiley, how do you plead to the count one charge of obstruction of officer in case number 24 CR025? Guilty or not guilty?
Guilty.
Are you in fact guilty?
Yes, sir.
And did you, on the second day of July 2022 here in Montgomery County, Georgia, knowingly and willfully obstruct Officer Matthew Mallory, a law enforcement officer with the Montgomery County Sheriff's Office, in the lawful discharge of his duties contrary to the laws of the state of Georgia?
Yes, sir.
And then, Mr. Brinson, how do you plead to the charge of obstruction of an officer misdemeanor in 24 CR031, guilty or not guilty?
Guilty, Your Honor.
Are you in fact guilty?
Yes, sir.
And did you, on the 28th day of April 2023, here in Montgomery County, Georgia, knowingly and willfully obstruct Marty Craven and Ron Bivens, law enforcement officers with the Montgomery County Sheriff's Office, in the lawful discharge of their official duties by resisting and failing to comply with the commands of such officers contrary to the laws of the state of Georgia?
Yes, sir.
And then, Ms. Dees, how do you plead to the charge of simple battery in case number 24 CR087, guilty or not guilty? Are you in fact guilty? And did you, on the 21st day of April 2024, here in Montgomery County, Georgia, intentionally make physical contact of an insulting or provoking nature to the person of Marshall Morris by striking said victim contrary to the laws of the state of Georgia? Is your plea of guilty here today freely and voluntarily given? Mr. Kite?
Yes, sir.
Yes, sir.
Yes, sir.
Has anyone tried to force you or coerce you into entering a plea of guilty here today?
No, sir.
No, sir.
No, sir.
All right, Mr. Childers, on behalf of the state, if you'll give the court a factual basis for each of these cases.
As to Mr. Knight's case, Your Honor, on about the date set forth in the indictment in that case, him along with a co-defendant got into an altercation with I don't know if it's Mr. Knight's ex-girlfriend or the co-defendant's ex-girlfriend. Ex-girlfriend that actually came to the residence where Mr. Knight was. Him and the co-defendant got into altercation with that victim. A fight broke out. She actually left the scene and went to the hospital, but a gun was drawn and shot at the car. Turned out to be it was a BB gun, and the BB gun is what hit the car. Did cause damage to the car. That's the reason of the negotiated plea of dropping the charges down. She went to the hospital, but she was released from the Memorial Health Meadows with a soft tissue bruise. So I don't think it might have not reached the point of aggravated assault, and that's part of the reason that we reduced that down. Mr. Smiley's case, Your Honor, on or about the date set forth in the accusation in that case, law enforcement was called to a residence because of the victim saying that the defendant was there and was intoxicated, wouldn't leave. And when they got to the residence, they found Mr. Smiley laying by a trash can close to the door. When they went up to the front door to speak with the victim and the homeowner or the resident there to determine what was going on, Mr. Smiley caught a second wind and got up and kept trying to come up the steps and go in the door. And they kept telling him to get back, get back. The victim said, hey, he's been fighting us with 2 officers. He was charged with the 2 counts of obstruction and a simple battery. Mr. Brinson's case, Your Honor. In Mr. Brinson's case, the law enforcement, on or about the date set forth in the accusation, law enforcement officers were going to the residence of Mr. Brinson. There's a custody battle going on between Mr. Brinson and Mr. Brinson's ex-wife, where he was supposed to relinquish the children at the Sheriff's Department parking lot and didn't do so, so they went out there, and there was a court order put in place. And he basically told them he was not letting them have the children, so he was arrested on that. And then the last case, Your Honor, Ms. D's case. This is a case where the victim and the defendant stands before you, a boyfriend and girlfriend. They were actually at the Sheriff's Department parking lot, I believe, when the victim said, hey, you know, she's assaulted me, she's hit me or something of that nature. After speaking with him and seeing some bruising or some marks on him, then he stated he had a video that she had saw him, and they observed the video. I apologize. I got 4 cases I'm trying to work through. They reviewed the video, and then they decided that there was a probable cause to arrest her for the simple battery, and she was charged with that, Your Honor.
All right, what's the recommendation as to Mr. Kite?
In his case, Your Honor, we'd ask that count 1 be reduced to a criminal trespass, be 12 months probation with a fine set at $500, drug and alcohol conditions in a Fourth Amendment waiver, no violent contact with the victim in the case, one being Amber Braddock, and restitution to the victim in the amount of $400. That restitution can be joint and several.
All right, you understand that recommendation?
Yes, sir.
And as that's your agreement?
Yes, sir.
All right, as to Mr. Smiley.
Mr. Smiley would plead to count 1, Your Honor. It would carry a 12 months probation with a fine set at $400, drug and alcohol conditions, and a Fourth Amendment waiver. We'd move to null across the other counts.
All right. As to Mr. Brinson.
Mr. Brinson would plead to the charge on the calendar of the obstruction, be 12 months probation with a fine of $400, drug and alcohol, and Fourth Amendment waiver.
Okay, this is not the one with the, going to be time served, credit for time served?
How long have you been in jail?
August 1st.
I also got some boiled peanuts from a roadside stand while driving through Georgia. I wonder if we went to the same stand. Probably not, because they're all over the place. But it was okay. It wasn't terrible. I just like regular peanuts better.
Yes, this would be credit for time served. That slipped my mind, Your Honor. This is credit for time served. He's been in there long enough.
I just remembered,
Is that right from the sheriff's department?
Pick it down here, pick it
This is the one we're reducing the bond.
Okay. You hadn't been in our jail for,
Yes, sir. It's not just for the same charge, but.
He's got new charges that we're reducing. This is the one that he's pleading to this misdemeanor. We're reducing the bond on what he's in jail for
gotcha.
now.
That's right. That's right.
This is not the credit for time served guy.
I just knew y'all had
Okay.
indicated to me y'all had somebody that,
We do with somebody else, Your Honor. So
Okay.
this is a probation sentence, and then later on, he has a bond in magistrate court, and I'm gonna go downstairs and try to get that bond reduced. So he will plead to this. This will be 12 months probation with a fine of $400, drug and alcohol, Fourth Amendment waiver. And as to Ms. Deeds, she would plead guilty with 12 months probation, a fine of $400, drug and alcohol, Fourth Amendment waiver.
Your Honor, can I interject? After Ms. Dees, the state had agreed to allow her to terminate early if all fines and fees were paid. We talked about that after this was all written up, and I can give the basis for that now at the appropriate time.
I did agree to that, Your Honor.
I mean, that's fine with the, if y'all agreed to it, that's fine. All right, Mr. Kite, that's your agreement?
Yes, sir.
Mr. Smiley, that's your agreement?
Yes, sir.
Mr. Branson, that's your agreement? Ms. Dees, that's your agreement? All right. Now, have there been any other, promises made to you to, in return for your plea of guilty?
No, sir.
No, sir.
All of you that are being placed on probation, you're gonna have to consent to the waiver of your Fourth Amendment rights, which means that while you're on probation, you and your property are subject to being searched without your consent and/or a search warrant, and anything found on you and/or your property could be used against you in a court of law. You understand that?
Yes, sir.
You so consent?
Yes, a fireplace, yes.
Yes, sir.
Yes, sir.
All right, had you stood trial in this matter and were convicted, you'd be entitled to an appeal. If you couldn't afford an attorney to represent you in that appeal, this court would appoint you an attorney. You understand that, right?
Yes, sir.
Yes, sir.
Ma'am? And do you understand that by pleading guilty here today, you're giving up your rights to such an appeal?
Yes, sir.
Yes, sir.
Yes, sir.
All right, I intend to accept the pleas of guilty from each of you and the recommendation, but but I'll give you the right to withdraw your plea and you can proceed to a jury trial. Do you wish to proceed with your guilty plea?
Yes, sir.
Yes, sir.
Yes, sir.
All right, as to each of these individuals, the court finds that, accepts their guilty plea, finds that there's factual basis for the plea, finds that they have freely, voluntarily entered into such plea, and the court imposes the sentence as stated by the assistant district attorney. You understand that, Mr. Kite?
Yes, sir.
Mr. Smiley, Mr. Branson, Ms. Dees?
Unfiltered.
You'd have 30 days from the date that this guilty plea is entered to accept your plea. You can file a motion to withdraw your plea if you file the same within this specific term of the Superior Court of Montgomery County. Each of you would have 12 months in which to file a petition for habeas corpus if you feel your constitutional rights have been violated in any way. Let's let the pleas be entered.
Destiny.
You're entering the plea, to count one, the court's now processing counts 2 and 3 as agreed.
Your Honor, while you have Mr. Smiley's file, here there's a bench warrant, 3524.
If you'll find it for me, I'll rescind it for you. Mr. Kite, as a result of your pleading guilty to the reduced charge of criminal trespass to courts, now processing count number 2 for you, okay? Anything further?
No, Your Honor.
All right, thank y'all. That concludes these 4 matters.
Didn't realize. We have no misdemeanor probation.
Do we have anybody from misdemeanor probation here?
That was Fozzie's fault. He distracted me. Completely distracted me. Okay. All right. I was going to do something, but now I'm going to do something else. So, Throw the Goats just sent me something right before. Oh no. Well, that was annoying. Throw the Goats sent me something right before we started this stream. So, it's from Kimberly Joy. And this is part 6. Okay? We're not seeing all of it, but we are going to see part 6. I don't care if it's a Rickroll. I love Rickrolls. So instead of doing what I was going to do, we're going to do this. Apparently the judge is done being a judge. Just done. Done with everything. Let's watch.
Back on the record.
Okay, we're back on the record.
You know as much as I know now. So, you can ask all the questions you want, but I don't know any answers. I'm going in blind.
Let's proceed.
Hi, Crystal.
I know Your Honor is disinclined to apply these rules, but I would just note for the record that the rules would provide that the questions that she asked would be within the scope of my recross. I'm just making that
There's been so much
observation.
back and forth that I don't know anymore.
And that-
What, but I don't
I'll
think
clarify
I
that.
don't
So
think
that
she had
was-
much left, or maybe you did. Were you questioning her about the legal 2000 or the what? was-
Right, so he was asking questions regarding my labs, right? So am I
Yeah.
allowed to?
Yes,
say-
yes.
Okay, so I was just gonna point out a lab.
There's the link if you want to see all the parts.
So BB,
Okay, B,
the
B,
double B, exhibit BB.
all right, I'm looking.
And then just for the record, none of these are in evidence, correct?
Not yet.
Okay, well, so just want to make
So
that
then
very
can-
clear.
Lab results.
Well, I want to make it very clear that nothing in her binder is in evidence, Your Honor.
How many of these, well, I think the concern here is, were some of these on her own initiative but not court ordered? Because there's an awful lot of them.
Yeah.
Is that the concern, that you're not sure about the
concern
integrity of
is-
some of
is
them?
simply that what I was referencing, Judge,
Yeah,
were exhibits that were already admitted into evidence.
right.
I don't know
Right.
what you're looking at, but what is attempting to being discussed right now would be a proffered exhibit.
Right, but is the concern that, I think, if I understand the concern
I'm
correctly,
a myriad of
there's
concerns.
a series of drug tests that you're concerned about, A, that they weren't court ordered, and B, that they may just be urine and not full hair follicle
They
screens.
lack foundation, this isn't the proper witness to authenticate them, they're not in evidence, they can't be discussed.
You
That's
know,
true.
That's fine, you can,
Okay, we'll move on. So you did test, some of these tests are on your own initiative, I take.
yeah, and they
Okay.
are hair.
Okay.
I have 2 hair.
Okay.
Move to strike, Judge.
Okay,
You can't
understood.
testify
No one's seeking to have them admitted now, and if drugs is gonna be, the backdrop of narcotics is important in the sense of how we got here, or historical rulings, but to the extent that we're proactively going forward, when the emphasis is there, then it's a matter of someone clean as of this time, and have they maintained that for a comfortable level of time. So let's move on. I understand what's been presented.
Okay,
Okay.
then,
Okay. Okay, so, but that, you can still question this witness about anything you're aware of that you want.
I think with the whole,
Pardon?
I think with the last question, I kinda covered.
It appears to be the
Yeah,
case, unless there's something
yeah.
else. Okay. Thank you
Okay,
so
so
much for your
I put
treatment.
that
Oh, I'm
there,
sorry.
I'm
Did
good?
you have anything further?
Oh, no.
Okay, thank you so much for your testimony.
Yes, thank you so much.
Who would be our next, witness? Who would our next witness be?
I guess then, we call me, Mario. She was the main one that I wanted, and I'm gonna be real honest, I don't know how these proceedings work and operate, so this is my first one. I am sorry, and I apologize to the court, it has to deal with, my ignorance of representing myself, but this is what I'm been forced to do, and I'm making the best of it that I absolutely can.
I think what might be best in these situations is it would be ludicrous for you to ask yourself, I've seen people do it, Q&A, ask themselves a series of questions and then answer it. I think it would be better, and you'd have to take the stand for it if you're offering your own testimony, you would make a statement to the effect of where you think we should go from here as to what's in her, Aslan's best interest, what schedule you believe should be implemented and why. And then Mr. Friedman would treat that as testimony and have the ability to examine you based on that. And then with his client, it's simpler because he's represented, he'll ask him questions and then you can cross-examine. So if you both, did they both raise their hands to be sworn yesterday? Did we get them sworn in yesterday?
Yep.
We did?
No.
Oh, let's go ahead and take care of that, that both please raise your hand.
Both parties stand, raise your right hands, the clerk of the court will swear you in at this time.
You and each of you do solemnly affirm that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth under penalty of perjury.
Yes, ma'am.
Yes.
Thank you so much. You can.
Very good. So if you wish on your case, you can call him. You don't have to wait for them to do the direct. You can call him on your case in chief, and it's sort of direct. Technically, it's not cross-examination, but since he's an adverse witness, it's controlled by the same rules. You couldn't ask him leading questions, etc. You could call him, and then Mr. Friedman can question him based on that, and then recall him on his case as to any issues you didn't address, however you want to handle it. Or you can go first with your statement as to where we should go from here, and then he can question you based on that. But if it's testimony, it really shouldn't be argument, or what's wrong with the record, or what should be done, or what was done wrong, or something, is saved for closing arguments. Testimony would be to the point of where do we go from here, and to address, in other words, it has to surround parenting concerns. It has to be about that, not all these procedural, legal, and other issues. That can wait for closing argument or briefing if you guys want to brief. So, with that said, did you want to make a statement as to the parenting history and where we should go from here, and then he can question you on that, or do you want to call him first and have questions for him, or what?
So if I call him, am I allowed to present my own evidence yet, or?
You could still make a statement, yes, as testimony later, it would be later instead of now. You can do whatever sequence you want.
If I can, I think were you asking if you could introduce evidence? And
Right.
I believe, Judge, that
Yeah.
was the question,
Yes.
could she introduce evidence if Mario's on the stand?
Right,
Or
right,
try to?
sure.
Can't.
I,
Oh, yeah,
And
that's
then,
fine.
obviously,
Or try to.
difficult
That's my question.
cases by
So-
far for the court to struggle with. All cases are difficult, but cases with two attorneys or two people unrepresented are difficult, but by far the most difficult is one's represented and the other isn't. It's really frustrating
I
for the
know,
court
but it is
and
the
for everyone
reason.
else. So how do you want to handle it?
So, that was my question, can I introduce into evidence some of
Like, if
my-
you show them documents and you want those admitted to evidence and the foundation's established, he looks at, yeah, I'm aware of it or whatever. Or you do it through your own, if he's unaware of it, you can do it through your own testimony.
Okay, yeah, if we could,
Would you rather him on the stand now and you question him, or did you want to make a statement and then have Mr. Friedman question you?
I guess, I'm sorry,
If I thought one method was that in your best interest more than the other, I'd guide you on that. I don't necessarily have an opinion on that, because eventually it's all gonna come out anyway, whether it's in this, just the sequence is what's important.
okay, then can we call him?
Okay. And unfortunately, we will need a third day on this. I'm gonna start looking. Okay, so,
Please, and
because
once you're
yesterday
stepped
was eaten up with attempts at settlement negotiations.
The parties
so-
have been sworn.
Your Honor,
Parties
again,
entitled
I
to
would just renew the inquiry I made of the court earlier. I now see that both the witness that was formerly on the stand as well as Ms. Heard's mother are in the courtroom.
True, but her grandma has always been here, and that,
Okay, is she going
the
to be a
findings will
witness?
be made on that one way, I get it, that needs to be on the record when she testifies. As far as our last witness, I didn't believe she was subject to recall, but if she is, and then that's gonna be an issue we'll deal with, that she heard the testimony.
Your Honor, forgive me if I'm misinterpreting the exclusionary rule, but I don't know.
But the intent of this isn't someone is in the courtroom, so automatically everything they say is discredited. However, it does indicate if it can be demonstrated that a person was likely to have been influenced or manipulating answers based on that, and often that argument is made and it's established.
So there's
They've
no-
been here so long, it's done, it's there. If either of them get called later, we will cross that bridge now. It's gonna compound problems if the court, it makes it worse if the court excludes them after they've been here for 80% of it. I'd rather just have the full-blown problem and deal with it rather than someone being able to say, look, you tried to remedy what couldn't be remedied right near the finish line. So just let it go. I'm not even sure. I don't assume either of them will be, if they are, we'll deal with it, okay? And that'll be right on the record. And sometimes it's a sound argument. Well, you heard this testimony, Judge, obviously, this sounds like it was manipulated by what was heard. Okay, so let's proceed then. Okay.
All right, so plaintiff's exhibit 46.
I'm sorry, Mario, this is not my show, this is Ms. Heard's show.
Do I need to be more, the plaintiff's exhibit 46 and the binders that, binder 404?
You're working off, just to be clear,
46.
our exhibit?
Mark, if it marks to 25, is there a book that takes us to 46?
What the? What in the world? Did you see how many exhibits she has? Oh my gosh. Oh man. Whew.
Exhibits from my binder that were in evidence from the prior trial are 1 through 30.
Yeah.
Anything beyond my number 30 is not in evidence unless it can be admitted. Now,
Right.
certainly there are many of them I intend or may
Okay.
intend to introduce, but what I was working off of were exhibits already in evidence from the previous trial.
If you have something that's not in evidence at the previous trial, but you have it at your ready, just show it to him and maybe you can
Okay.
establish.
So it was the talking parents record.
What number?
If you go to your 2560,
What number in the
We're in
binder?
exhibit 46.
that's what it says here, right?
Mr. Freeman, take a look at what she has. see if it
They're my exhibits, Judge, so
Right,
I'm
but-
aware. And
Well, true, but you may not
I
have
can
broken.
streamline this, Your Honor. These are absolutely a complete message record
Okay.
from talking parents. There's
Perfect.
no admissibility issue. If we'd like-
Perfect. If 46 is admitted, you can ask him whatever you want within reason. All right, go ahead.
Right, so 2560. And we're gonna be starting about halfway down, I think, with the date of, actually, the whole page. From 2560 to 2566. Can we review those pages?
I'm sorry, what are the page numbers?
2560
Mm-hmm.
to 2566. And these are messages from you, correct?
Yes.
Okay. And they're messages to, who'd they be to?
By the way, what are the dates of these?
Oh, so this would be from, August, well, from the very top it says August 3rd. But the ones on
Of last year?
August 3rd, 2022
Okay.
to,
They're not her exhibits. They're his exhibits. He did this.
January.
Of 23, okay.
No, to July 18th of 2023.
Yeah, about a year span,
Yes.
okay.
Yeah.
All right.
So, and these messages that you're writing are to who?
You?
Okay, and were you aware that I was no longer on the app and nor, was not ordered by the court to be on this app?
Sure.
Okay,
Do you understand the question?
No, I do not.
Okay, break it down, please.
you are aware that I did not have this application?
I wasn't aware.
You were not aware?
It's what you were said, but I was aware you still had it.
Okay, so what is, if you go to page, no, let's just go to the very first page of that same exhibit. So that's gonna be 2455. At the top, it says a complete message record.
I'm guessing custody. Child
with
custody.
Who and Mario Okaperi? What's the name?
I'm trying to find the page. No longer a user.
Correct, so it's not my name. The name does not say Kimberly Joy Hurd.
Correct.
Okay, but admitted into evidence already through Ms. Chrome's evidence. And that's going to be, this is what's already admitted into evidence, that's what we're going off of here. Number 13,
Is it in your exhibit book here?
it's not in mine, this is already admitted into
Is it in
evidence,
mine?
so.
Well, I don't have it in mind, so I don't.
So do I need to resubmit evidence that's already been submitted?
Well,
I don't know,
if you wanna use it as-
did we even have 46 up here? Yeah, we don't have 46, but it's all right, go ahead. You can establish what it says and
Okay.
we'll go.
It's
from
all
there.
right. Just go.
At the
Just
trial
do it.
on August 16th, 2022, she admitted into evidence, and it's admitted into evidence. Number 13, the same record, and at the top, I would need him to say it, it clearly shows the name, Kimberly Hurd and Mario Okaperi.
Okay, do you see it at the top then?
It's not here, Judge, it's right, objection moved to strike, she's testifying.
So it's already
Is he-
admitted into evidence.
Okay, but is he
You
looking,
didn't
is he
hear my
looking,
objection.
yeah.
I'm not
okay. Again,
disputing
is he
that
looking
there
at,
were
is he
56
looking at
pieces.
number 46?
But she took, number 46, yes, he was looking at. The document.
What do you
she's-
want, okay, which one do you want him to look at right now as we
So,
speak?
right, so
Because he
number
can't
13
see that part that
Okay.
makes the reference you just said, so
So he
direct him
stated,
to it.
the witness stated that he didn't know that I wasn't on the application anymore. And that's what I'm trying to establish,
Right,
is
but
that
if
he
you
did know.
discredit him based on that just make sure he's looking at the same paper you are.
We've
If you
had
wanna
a
show it to
horse
him
in
'cause
court
it's not
before.
from him, that's
Okay,
fine.
so, okay, it's already admitted, so,
Yeah, but he may not be looking at it.
okay,
Is he looking at it?
so do I need to show you?
Go ahead, show it to him.
And can you read the name up there?
Kimberly Hurd,
And,
Mario Okaperi.
So when you see the name, no longer a user, does that indicate that maybe I'm not a user anymore?
No, because that paper was printed August 3rd of 2022,
What paper?
the one you just showed me,
Okay, so you knew that right off the top.
because it's on the bottom of the sheet.
Well, let me, was the offer of proof or purpose of it, you never received this material, is what you're saying, you never received it?
I was not on Talking Parents, it was not ordered by
So
the board.
you weren't involved in these communications?
No, I'm not, and that's what I'm trying to establish.
All right.
He had, okay, so from,
So these are just communications from him that you didn't
I
receive
never
or respond
received,
to?
he was, so, yeah. So,
Your Honor, they're received.
Mr.
they were
Opari,
not
The
received.
messages say red when they
Mr.
are opened.
Opari, we will address this on redirect. It's fine. It's a bit
Okay.
confusing, but we'll.
So-
don't worry about it.
When they are received at the bottom, okay, let's go to, we'll do it now. Okay, 2560. When a message, let's start from the top. What does it say? August 3rd, 2022. What does your message say?
I'm finding the page, hold on, please. On 2560,
Correct.
says here,
All right. And then what is there something attached to that message?
yes,
Okay. And then the next message down says,
another copy,
okay. And then there's something attached?
yes.
Okay. Right below that, what does it say?
No longer a user viewed this subject,
On?
8/4/2022.
Okay. And what does it have that indicates when I view it? What's the icon?
An eyeball, it looks like?
Okay. So that, would you agree, shows when I view one of your messages?
Yes.
Okay. So as of that date, I viewed the application. So now let's go down to,
So the purpose of this, you never received any of this?
now I'm going to establish for the last year, he hasn't communicated with me. He's communicated with me via app I don't have anymore.
So you never received it? Okay.
Right.
All right.
So, August 4th, 2022.
So you never responded to any of this?
You're asking her, Judge.
Yeah,
I've
there's no
sent, I've sent
conversation,
him, I've
it's
sent
all,
him
it's,
messages via text messages, which they're not admitted into evidence.
Right,
so
I get
have to
that,
wait. But he was responding to those text message via an app I never saw. And
Okay.
I can prove I never saw it because he
so
will,
this will be a lot of communications from him where there's no responses?
this will be a lot of communications from him responding to me in an app I don't have. So his form of communication with me for the last year,
So are you, is this just all his communications or are you responding?
I didn't even know. I didn't know he was using this. I told him I didn't have the application more. I was using text messages and emails and letters to Mr. Freakman.
So then all these communications should just be him with no response from you?
Right, he's
Okay.
saying that I'm viewing them, I'm trying to show that I didn't view them.
So none of these are purported to be from you, they're all him just
Right.
arguing with himself for a couple of years? or
Yes,
what?
exactly, that's what I'm trying to establish right now. I know,
Okay.
it's crazy, so. Okay, August 4th, 2022. You sent a message, correct?
Yes,
August 6th, 2022, you send a message, correct?
yes,
And we can keep going down the page to the bottom, we get down to the bottom, September 17th, 2022. You send a message, right?
yes,
Okay, between the dates of August 4th, 2022 to September 17th, 2022, did no longer a user view any of those subjects?
no,
Next page, page 2561. At the top is a message from you on September 19th, 2022. Can you read that?
here are some photos of Aslan.
And how many photos or attachments are there?
4,
4, okay. What's the next, September 19th, 2022, can you read that one?
Aslan lost her first tooth today.
And attachments?
There's 2 of them.
Okay. Let's go down all the way to the end. October 23rd, 2022, can you read that message?
I said again, you can just not FaceTime and you can see Aslan at Family First on Tuesdays and Thursdays from 6 to 8.
And that whole page, did no longer a user ever view any of your messages?
No,
Next page. On the top is a message, October 27th, 2022. From you, correct?
yes,
Okay, we'll go down a few. November 1st, 2022.
I don't get it. Why are you sending messages month after month if it appears they're not being received or viewed, or you don't have the correct connection to her or whatever, you know?
Because this was after our trial in August and the court ordered to use Talking Parents.
Fair enough, but the order is not a hyper-technical one. It means it's not just to comply for the sake of complying, but to facilitate communication. And I don't know if this is valid at all, if this is true, you had an affirmative obligation to point out to Mr. Friedman the obvious. I'm talking to the brick wall here. I keep sending messages. Something's changed. She either declined them or she changed it all. Let's get this correct. He would have shot a letter off to her or some indicating, you know, what, do you want to receive these communications?
So it's his
that
fault?
you terminated this service or something? I mean, I want everyone to understand, comply with the spirit of orders, not just the orders such as, this is to help and facilitate communication, so.
This is
if one
her
or both of
fault,
you
100%.
communicate for months and months, and the other seems to have logged off or selected some other modality or something, they're not receiving it, bring it, and like you represent, bring it to your attorney's attention, and,
Your Honor.
well, never mind, I mean, so I'm a little confused. You're saying that he communicated for months and months,
For a
knowing
year,
that
over a year.
knowing that he wouldn't receive an answer and that you couldn't answer because you were oblivious to it?
Correct.
Okay,
And I mean, this would be my testimony, so I can't say
all
that
right,
right now.
no,
Okay,
yeah,
so
it's okay.
there's an order from after the August, your order, sir, from after the trial on August 16, 2022. This is the order. It was entered
Sure.
October 17.
I can only hand it to him.
That's all right.
Ask for it, but he should be able to view it.
About the, talking parents?
Yeah, can I, it's your findings
Right,
of
but
fact,
again, the
conclusions of law.
purpose of this kind of order is
No, can I
not,
just-
okay, I want everyone to understand,
Okay.
not just talking, it's education
not
for you
in
guys
there.
in the future. This isn't just talking parents or some other requirement for the purpose of wasting everyone's time, money, and energy. It's for the purpose of actually
They're really hard to throw. They're very big and bulky.
communicating. If you have reason to believe, if one or both of you have reason to believe there's a breakdown somewhere, someone, I'm not able to access this person anymore. I don't know why. You reach out to them by some other method and say, here's what's happening. If you prefer to communicate some other method, let me know. You guys need to start dealing with each other fairly. I mean, you
Your
know.
Honor,
Yeah.
can I give him this order?
Did you hear what I said? Did you hear what I said?
I did, but
Did
it's
you
not in
hear what
the
I
order.
said?
Yes, sir,
Why were you communicating months after months with someone who wasn't receiving it?
because I was told to continue. using
Okay,
this-
well, did
the
you
app.
hear what I just said? What should have we done when we find out that we're wasting all of our time? What's the better approach? If we communicate for 6 months and no one's receiving it, what might some suggestions be, based on what you heard from me?
Well, Your Honor,
What do you think someone should do?
you told us to use text messaging.
Okay,
We've been using
I'll do
text
this with a
messaging. That's
fifth time. Effective parents don't have such a myopic view that I'm gonna comply just for the sake of complying, and if there's a breakdown or problem, I don't care, I just wanna comply with orders. This wasn't for the purpose, or it should have been obvious, of amusing me, or humoring me. This was for the purpose, this wasn't the purpose of issuing pointless asinine orders for the sake of it, to see who complies. It was in the hope that it would improve communications between the parties. So if you guys don't understand that if there's a breakdown, spend 18 seconds reaching out to someone by some other source and say, hey, what's going on? If you're not on this app anymore, what can we do? We have to do something. Can you get back on it, or here's an alternative? Mr. Friedman knows what I'm talking about, so from now on, if we see anything like that, let's
Your Honor, since
rectify.
we're talking about it, that's what occurred.
Okay, it
That
is?
Precisely
You
what
did?
occurred. We attempted to direct her
Okay.
back on numerous occasions to the
How
app.
come he doesn't
Well,
know
Your
the
Honor,
obvious?
The parties, as of June of 2021, Your Honor ordered the
There's
use
no
of talking.
order.
Yeah, it's in the June
There's,
20.
it's not in an order.
Well, be very careful what you say. Subsequent to that, Your Honor, Ms. Heard used the app and then unceremoniously decided to stop using
Okay.
it.
That's
I
not
view
it.
the, I
Ms.
view,
Crone,
okay.
And then my office sent numerous letters about that. My
Why
client-
didn't you
my
tell
client
me
had
that
stepped up.
you contacted your attorney and said, so you agree with me? You said, I don't wanna waste time communicating with someone who doesn't receive
I
it.
thought I said that, sir.
So
I'm
you
sorry.
you contacted Mr. Friedman. Okay, you guys all may think this is productive to try and blame each other on the communication issue. I think what's productive is which one, if either of you stepped forward and said, can we rectify this? These communications are not being received. I want problem solving on
And I
an
have that in
adult
my
level,
evidence.
guys.
I
I
have
don't want people acting like 10-year, oh, he did it or she did, so I don't have to. This isn't a test where some orders are kind of tests, I have to admit. But this isn't an order to test to see who complies or who can get in trouble if they don't comply, or who we can blame for not complying. This is for parties to communicate effectively, hopefully, to co-parent. That's what it's about. And if there's a breakdown, rather than coming to court a year later and pointing the dirty end of the stick at each other, who was the adult in the room, if any, who reached out and said, let's get this solved?
I did, Your Honor.
He knows what I'm talking about. Mr. Friedman knows what I'm talking about. I don't know if
No,
anyone
he
else
doesn't,
does.
because he keeps lying to you, saying it's in an order that it's not, and that's what I'm trying
Okay,
to show
but the
right
point,
now.
okay.
He is.
Okay,
And I can prove it right
he
now.
knows what I'm talking about. Even if for some reason you think he's dishonest or misleading the court. Which there's no evidence of, and he wouldn't, but
I
even
will
if he
introduce
did.
that into
Even if
evidence.
he did, do you guys, I'm required, I'm not trying to jam you guys up, quite the contrary. I am trying to clean the record up, because I'm gonna make findings on who gets it and who doesn't. And so far in this issue, neither of you seem to really get it. Everyone, no matter what I said about, this is about growing up, communicating better, and if you can't get hold of someone, to reach out by some other source and say, let's reestablish. And instead, it's in one ear out the other and say, no, it's his fault, it's her fault, no, it's his fault, oh, well, he's lying, she's lying. Does anyone understand what I'm saying?
I do, and I can show
Do you?
you through my
And
evidence
Mr. Friedman,
that I tried to
obviously,
do
it
that.
does, and the party may not, is he's still a little on your theory of let's see who's to blame or what orders violate or what it is. Now, if they did, however, if they can establish they reached out to you about this, then Mr. Friedman certainly gets it, and I assume his client is just nervous and not answering my questions, but he brought this to the attention of Mr. Friedman. Did they bring, this whole year, August to July, almost a year,
No.
did anyone bring to your attention, did you bring to their attention, I'm receiving nothing, or did he bring to your attention, I can't tell whether you
Yes.
viewed it, received it, or what do we do?
Yes, I have, and it's in my evidence right here. I've sent emails, I sent text
Telling
messages,
him that
and I
you're
sent
not-
letters to Mr.
that you're
Friedman
not
saying I
receiving
don't
this
have the
material.
application.
Okay.
I'm trying to communicate with my daughter. Can we please set up a schedule? I will follow whatever schedule you ask.
Okay.
Please, can we respond? And I
Okay,
get
what,
ignored from everybody.
did you suggest you get restored to that app, or you use a different method of
Yes,
communicating?
I asked for Our Family Wizard,
Okay.
that we just use text messages,
Okay,
because I couldn't afford the application anymore, and I let them know this.
Okay.
I sent it to his
that's what
attorney
I'm
back in
getting, that's
May.
what I'm getting at, I don't want
Yes.
people sitting passively
Yes,
back
and I
and
can show
expecting
that.
me to care that much a year later, when you guys didn't care to solve it
No.
within a year.
I tried
Both sides are
in
now telling me,
numerous
yes,
ways.
we did communicate with the other side on it, but it still didn't get solved. How did we finally solve it, in
When we
July?
were-
What
when
method
we
do you
were
guys
full-
use to communicate now?
Text
When we were
messages.
before your honor for the first time, your honor relieved Ms. Hurd of the order prescribing the use of this
There's
application.
no
And
order.
since that period
It
of time.
doesn't
there's a
matter, whether there's an
stipulated
order or
it's in
not,
the minutes.
somebody say to the
Well,
other
we have
side,
to have
let's
some
communicate
form of
this way.
service.
Let's communicate this way.
It looks like I'm violating orders, and I'm not, Your Honor. I don't want to be
Again,
perceived
I
as
don't
violating
care.
orders.
I don't care. You guys are obsessed with this. I don't care.
Okay.
I don't care. If you guys, I'm gonna make findings based on what you both said, unless you wanna clean it up, but you guys keep doubling down. That all that matters is we can show that the other side is the one who's non-compliant in this, and that we didn't have some affirmative adult parenting responsibility to solve this issue.
Okay. Your
I
Honor.
care, I don't care about the technicalities of it, I care who's the adult in the room and said, let's solve this, you're not receiving it, or I'm not receiving it, what do we do?
I
And I'm
reached
gonna
out
make
to
findings
his
on that,
attorney
and you guys
via
have boxed
letter.
me in, you both want findings, that all I should care about is who technically might be in noncompliance, and that both parties think it's incredibly unimportant to bring to the other party's attention. You're not able to receive my communications, and that no one thinks that's important to rectify that.
I
When you
did. I
have a
reached
Down
out
syndrome,
multiple
special
ways.
needs child, no one thinks that's important. It's best to wait months and blame each other in court. Are you guys serious?
I've tried, Your Honor, and
You know-
this is my point, what I want to bring to this court. I've been trying, I've been begging
Now,
to
in
talk to
fairness,
my
Mr.
daughter,
Friedman,
and
you're
I
saying
brought
you
it to
did
his
send
attention.
communications on this.
Your Honor, both Ms. Crome's office and my office sent them in. For
So you
context,
agree?
Your Honor,
So you agree then?
I agree that we sent correspondence attempting to resolve it, and for context, Your Honor, there is a reason for the parenting application, okay?
And this is what I'm talking about.
Ms.
Just
Hurd,
believe
and
whatever
this
he
is
says
it's
blindly.
in evidence.
Ms.
Ms. Hurd was.
What evidence do I believe anyone right here? I'm too busy getting my blood pressure up about the way you guys are dealing with this.
I respectfully, Your Honor, I take some umbrage with the "you guys" comment, okay? I take some.
But
I
no,
don't
no,
know what
because
it
the
is.
record is my friend here. The record is I asked you 5 times, and instead of saying, yes, we reached out, we agreed, you keep saying,
Your
well,
Honor,
the
I'm
order
looking at-
says this, the order says
Your
that,
Honor,
you
I'm
know?
looking at a transcript of the proceedings where Ms. Roberts, I don't know what you want me to
This is June
say.
of
I told you exactly
2021.
what to say.
And what is that, Your Honor?
After you establish your position as to what the order was and that you're in compliance, and on these dates I sent out these letters to indicate, yes, that's what needs to be done. Instead of the blame game, if someone's not receiving critical material,
That is what we
we
did.
need to establish what is the better method of what, if you can't be on this app, what should we do?
That's what I
And if
asked
you're
that.
saying that you
I asked it.
communicated that, perfect, that's the first thing you should have told me, not all this other stuff. Come on, guys.
My client's on the stand, Your Honor, I can't.
And I've been asking him, and he says, he can give me, he didn't tell me
And
he
Your Honor-
contacted you to rectify, but apparently he did.
And Ms. Crone, prior to me entering the case, Judge, because there was a lot of correspondence with them as well. And for context, Judge, there's a reason that parenting applications were stipulated to and entered into orders, and it was because Ms. Hurd had broken into Mr. Okapari's home and been
Okay.
charged with that.
Now-
She had, this is in the record, so that's why we, Judge,
Okay,
is that not why the court orders that type of an application?
What, do we still have this problem, or how do we
this is 2
communicate from,
years later.
How do we communicate from August?
Well, Your Honor, when we were before you, I believe it was in March, or July 2023, relieved the parenting application burden.
Throw the goat
and
found
stated
this.
that substituted it
Yes.
and that is what they-
Substituted it with what?
Text messaging only, and that's what they've been
Is that
doing.
acceptable to them?
It's not our preference, but it is
Do
acceptable.
they respond adequately to each other?
That's my understanding. They've been,
I would disagree.
How would you want him to communicate?
No,
You didn't,
we-
if you
we-
didn't follow
We
through with
already
the
said
app
our
and you don't want
language.
text messages, how do you want him to do it?
Your Honor,
You
if I could say something without being interrupted, that was never ordered to be used talking to parents, and I did reach out to Ms. Chrome, I reached out to Mr. Friedman, but I couldn't afford it. I had a waiver for our family
What,
visit.
okay, when
Could
is
we
someone
please use our
gonna, when I
family
tell
visit?
somebody, here's the artificial answer you should give the court, even if you don't mean it, to impress the court that you're the problem-solving parent. You
I
guys
just
have each
said,
told me
I asked for
180,000
another
times
application, if we
what
could
your
use
position,
that.
you've each told me 180,000 times what your position is as to what the court order is, but no one has once said, yes, regardless of what the court order is or isn't, once we identify a problem and that there's a breakdown, we need to intervene and either get back on that appropriate app, or if we can't, then agree to some other method.
Right. And we did that, and I offered, can we use our family wizards, or can we use text messages? I offered alternative means, and I was ignored. And I know you're listening, this is where I have the problem with, where you listen to Mr. Friedman and you believe everything he says.
Okay,
and
you're
you
just,
don't listen
young
to
lady, you're
anything
making
I
a
say.
dreadful record to yourself, because Mr. Friedman's quite upset at me right now, because I indicated to him repeatedly on the record, I'm tired of hearing about what the order is, did anyone
did
reach
try,
out?
yes, and
I love
tried,
this
and I can
judge.
show that I tried.
I
have
love
proof
him.
that I
If
tried.
you
I
think
tried
that this
every way
dialogue
I
is
did.
me believing either of you, that think either of you handled this the way I think it should be handled, I don't know what to tell you.
Your Honor,
I would
couldn't
not be
afford
this
the app, so I
upset if
tried to
either of
find
you,
another way.
if either of
Yes,
you
I
handled
did.
this properly.
I sent the message, I sent emails, I sent letters, I asked, can we do our family wizard, I have a waiver. I offered 4 additional ways to communicate.
Okay.
And they ignored me, and he instead replied to me when I try to use any of those methods via this app that he knows I don't have, talking to nobody. I tried. I can show you the emails. I can show you the letters. I can show you the text messages.
At
I
what
can-
time in this 1 year period, how long did it take in this 1 year period? Because he keeps sending material. The more
I
you
didn't
guys
know
double,
this-
the more
I
you
didn't
guys
know.
double down, it's more like we leave our common sense in the hallway. At what point during this 1 year period that you're not receiving messages, did either of you bring to the other's attention,
I
we got a
did.
problem here?
I did. I brought it
How-
to him immediately, and he kept saying, use Talking Parents. I go, I can't afford that application.
Okay,
When I reached out to his attorney,
alternatives
I
did
said,
you
I can't
offer him?
afford that application.
What
Can we do-"
alternatives did you offer him?
I offered Our Family Wizard.
Okay,
Can we please use
you,
that?
he's on the stand, since you guys are, both sides are so fixated on this rather than how do we cure it? Because I could get this cured in about 5 seconds, but you guys aren't interested. I could, if expense is a problem or anything else, there's several suggestions if you guys can't handle it. He's on the stand since I told you that I care far more about the maturity and problem solving than the actual order compliance. And I care more with the spirit of the order, which is to establish contact, rather than just the hyper-technical question of who was in compliance or not. If both of you are insisting you brought it to the other side's attention, and then I'm getting the wrong idea, then you can examine him on this. So go ahead. You said from 8/3/22 to 7/18/23, he's sending talking parent messages, it's almost a year, and you're not receiving them.
Correct.
So,
Um,
go ahead.
okay, so, all right. Were you, Mr. Okaperry, were you aware that I suggested and offered to use Our Family Wizard?
Yes.
Okay. Was there a reason why you didn't want to use it or why we couldn't use it?
Talking Parents is free.
To who?
Anyone. You don't have to
The
pay
app-
for the app.
Talking Parents is free via what mechanism?
The computer, the phone,
Okay, not, the phone is an application, you have to download the app, is that correct?
the app is free.
Okay, so and then for this, purposes of this whole document here, is that free?
I don't know, I've never printed this stuff out.
Okay, it's not free, it costs $60, so it's not free.
No, you guys, the court spent a lot of time and energy and getting my blood pressure up at my age, which I shouldn't, about what I think the takeaway of this should be, how we problem solve as adults, but everyone's saying, no, 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 I'm right, he's wrong, I'm right, she's wrong. And if you guys are insisting on developing this and insisting that the court
Right,
make
I'll just ask
findings
one
of
more
it,
question.
then let the other side have a wide berth as to their questions. Let her ask her questions, and you will able to ask her everything you want about this issue. Go ahead. Everyone wants me to have a
Mr.
complete
Did you try
record.
to attempt
Let's have a
to
complete record.
Contact me during this time in any other way?
No.
Were you aware that I was trying to contact you?
Yes.
Via what mechanism?
Either email, text, or through my attorney.
Did you respond to any of it?
No, sir.
Okay, all right.
Sorry.
What was the price of this, the
It's-
talking parents?
For the application, it's $10 a month. And I
Okay.
know that sounds silly, but when, I'm sorry, I'm pinching pennies, so, you know, if Mr. Friedman would like to make fun of the fact that I can't afford $10 a month.
I don't think that's what his concern is.
The testimony of my client, I'm just clarifying for the record, it's free.
It's not free via
Well,
an
it's not
app.
free as a specific form of it that she wanted, but that the access is 100%.
It is, but
Yeah, and
But then I'm limited to what I can do with that. I can't print, I can't look at the calendar, I can't upload in the calendar. It becomes very limited, and Our Family Wizard, I could get for free. I had
if
a
you
waiver.
guys figured out by now,
And
I
now
don't,
we're
I
on
don't
it.
have problems with either of you are telling me, I don't know how the breakdown occurred. My whole concern is that
It did.
no one did anything for months about this. You're saying you did bring it to his attention, and he did
just
say,
admitted that
he
he
didn't
did.
respond, so he did say that, so go
Yeah.
ahead.
So So that's it, like, that's what I want to establish. I tried, he knew I wasn't.
I get it, the
in
court order is in his favor, he said, these are the communications that have to occur.
There is no court order with that,
Well,
Your Honor. If you're gonna find
I
it in
think
his
that-
favor,
okay.
please, I would like to ask what
We're
page
gonna
it's on.
we'll find it, but
Okay, fine. Then
I think
let's
it
do
goes
that.
beyond that. I think even if the court order's in his favor, I don't think it's reasonable to sit back therefore and do nothing in response to your inquiries, but he stated.
I love that video.
Mr.
I love
Friedman,
it.
more to the point.
Put that
than
goat down.
correctly,
A little
stated
horsey.
that they were sending you communications as to this, that you're no longer on Talking Parents. So if you're saying you sent material to him, did you receive from Mr. Friedman's office communications? You're off Talking Parents, what's going on? What do we do about this? Did you receive those?
They didn't send messages like that. They sent, you are required to use our Talking Parents. That's the
Okay.
only way you can communicate with him about Aslan, and that was it. It was it, and there was no alternative means. There was no other options. There was no listening, compromising, negotiating. It was you do it this way, or you don't get to talk to your
All
daughter.
right. Go ahead and continue with the questioning, please.
But that's all I wanted to establish there. That.
So, I
just-
guess my
tried.
question isn't important because all this other stuff's important. How should we communicate from this date forward?
You had said yesterday to use our family.
Forget what I
wizard. I'm
said,
okay
what
with
do
that.
what do you think?
I'm okay with our family wizard. I'm okay with texting. I'm okay, I'm open to things. Our Talking Parents was an issue because of that small thing. When I tried to use the free version, which I did try, when I went to print out text messages or print out this, because we obviously need it all the time, because I'm constantly having to prove myself, I couldn't print it out. It either cost $60 or I'd have to do screenshots that you couldn't even read. So I attempted that. I tried the free version, as Mr. Opaperi suggested. It wasn't feasible because I couldn't get on the calendar. I couldn't put anything on the calendar. I couldn't view the calendar. And I did let them know this. I couldn't print. I sent them a whole letter, which I have in my evidence, and we can look at it, that look, these are my restrictions. Is there any way that we can use our family wizard? And I gave them all of that. They had no restrictions. I did try to comply with the free version. For our case, it was just not gonna be feasible because it
So
restricted
you're
us.
fine by the methods you just suggested?
I'm sorry?
You suggested 3 methods that you're fine by if the order's modified.
Right, yeah.
But I have to be, one concern is, it has to be material the court has access to, because people tend to behave a lot better, and we
Right,
don't
and
have
that's-
abusive,
right.
disparaging language if
Right.
they know, it's not just for their eyes only, but for the court. But that's it, you heard what she said, if the order is changed, if you think it shouldn't, tell us. If you're willing to consider those options, which ones or other options you think of is how we should communicate from now
Our family wizard's fine.
on. Okay. Right. You're saying you suggested that months ago?
Yeah, I suggested this for the last year and a half, since May of 2022, and I have documentation to Ms. Chrome showing that.
All right, it's a high conflict case and they wanted their client to be careful and just comply with the order. Okay, so let's move on.
Which I'll go on record, it's not in an order, Your Honor, and if they could point to the date of the order and the page, they can't.
I can.
Not
Is
in the
it
minutes,
mainly like a
Order
minute
after-
entry or video?
Order after March 21st,
That's when we
2023
put it in there
hearing.
fraudulently.
Because we cited to, it's also in a certified transcript of proceedings, it's in a minute order, and it's in a March 31st order.
And in the minute, and in the
It
transcript,
may-
he says, we're just gonna do text messages. He didn't order talking
No,
parents.
it's Ms. Roberts, Amanda Roberts speaking on the record,
Okay, that's the
stating.
minutes. That's not an
No, it's a
order.
certified
March
transcript of the
31st.
proceeding,
From June 2021.
which is when it was ordered to use talking parents. I'm not
But it's
trying to
not
go
in
on
an
about
order.
this,
A
guys.
minute order and a
I'm
transcript
literally
is
not
not in
trying to have
order.
this conversation.
It's not in order if it's in the
Okay.
transcript.
It is
It's
the
not in
court
order
record.
if it's in the
They-
minutes.
They said it's
Your
in
Honor,
an actual
please,
order
I beg
though.
of this
It's
court,
not.
I beg
It's
of
not.
this court.
I would
March
like
31st of
Not
what?
the transcript, not the minutes. Point to the order.
March 31st of what year?
2023.
Thank you. I'll look, in the meantime, proceed with your question, because there's many important topics that
But it-
the court probably does care about.
And I would say in that, I would like the transcripts, which I have produced, to be looked at, because you did not order talking periods. But
Okay.
Mr. Friedman put it in the order anyways. He put it in there despite
Fine.
your directive.
But if it's in there, unless it's overturned as being an inaccurate order, it's the controlling order. If someone wants to argue it contradicts the minutes of the video, that's a discussion we can have later. You agree at
Okay.
this point,
Yes.
both of you, that, to Our Family Wizard,
Yes, yeah, that's fine.
and there's no charge, right? Or 99 a year, whatever.
No, there's a charge for that.
There's a charge,
yeah, yeah.
there, yeah, it's 99 a year. I
$99
think
a
I
year,
can
Judge.
get a waiver. So,
Okay, so we agree to that.
yes.
Good.
Oh, Rebecca, that was awesome. You found the best stuff, man. So yeah, this is part 6. Let's just see what's going on here. Oh my. Oops, wait, that's not what I wanted to do.
Very good.
37 videos. There's 37 parts to this, guys. I'm just looking about how long they are. So no, they're not very long. Ha. 1 month ago was the last one. Oh, was the last video from November 12th. I don't think it's over. The trial is not over yet. Because that's just a motions hearing. I'm so glad she's put it up there, though. Okay. Yeah. If you guys have spare time on your hands, you guys have a playlist ready for you. Oh. The best at raising blood pressure. It's funny how the chat was so divided on that one. I hate the judge. I love the judge. She's a pain. He's a pain. Oh, man. Should I do this whole thing? It's not over yet. I can do this whole thing, or I don't have to do this whole thing. Just I'll ask again in a little bit to see if we want to do the whole thing. All right? I'll ask again like next week to see how we feel about it. Maria, thank you so much. Thank you so much. I appreciate it. I'm trying to get to the bottom of chat to see who got them. Scrappy Doo. Wonder if... Nice. 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 Alright, guys. I need a small break. So 5 minutes and then we'll start OJ. Alright? Thank you so much for coming out. I appreciate it. Rebecca, thank you so much for that clip. It was awesome. And I shall talk to you in 5 minutes or tomorrow. Oh, bonjour, Charlotte. Bye. Oh, wait. Au revoir. Au revoir.
Got these life echoes, digital dreams. Through the screen, her blue eyes gleam. Wicked humor, sharp as a knife. Her stream sparks electric light. Late night when the world sleeps, she's the friend that there's no